Hello, everyone. A public charge. You've probably heard that being talked about in the news this week. What does it mean to be a public charge? Who does this new policy impact? And how will it be applied to immigration? I answer all these questions today and more in today's video. My name is Raluca Hanea. I provide immigration, estate planning, and family law services at my office in Lawrenceville, Georgia. Nina Clear, my marketing and office manager, is here with me. Thank you for all your likes, shares, and comments as they help others to see our videos.
Okay, so first things first, what does being a public charge mean?
Before I answer that, I want to point out that not being a public charge is nothing new in immigration. When anyone fills out an affidavit of support, they say that if the person that they are sponsoring becomes a public charge within a certain time period, they will be financially responsible for these people, the immigrants. Even people applying for a visitor visa are scrutinized to see if they have the money to support themselves while they are here in the United States, and if they have enough money to go back to their country. So that being said, there is something a little different about this new policy. So I think it is important to explain it to everyone.
Okay, so what does being a public charge mean?
Being a public charge means that the government helps you or is likely to help you financially.
Can you give us some examples?
Sure. And this is where it might be helpful to explain what is different with this policy now. What the new rule says is that those who have used SSI, which is Supplemental Security Income, TANF, which is Temporary Assistance for Needy Families, SNAP, which also is known as food stamps, Section 8 housing, this is when your housing costs are subsidized by the government, or Medicaid, will have every month that they have used these programs counted as a point against them. And these points will be added up when they apply for citizenship.
And just to clarify too, it's citizenship or like to remove conditions from their green card or different things like that.
Yes.
Too,
yes.
So, okay, and that might be important to note too, is that this new rule isn't just for those, like I said, but for those who want to become a citizen.
That's right. But remember, we always recommend to our clients that they apply to become a citizen as soon as possible.
And why is that?
Because you have more rights as a citizen and you won't be subject to changes in the law, such as those happening now with the new president.
Okay, so you said that this has been a rule for a long time. Tell us more about that.
Yes, it has been. Anyone granting an immigration benefit, such as a visa, green card, or citizenship, has had a review done of their totality of circumstances to determine if they are or may become a public charge.
And what do you mean by that, totality of circumstances?
The officers usually look at their age, health, family and financial status, education, and skills.
And you said that it has always been this way?
Yes and no. There have, of course, been changes to the rule over time. In January 2018, for example, the rules changed so that the officials outside the United States were able to look at not only the factors that I just mentioned above, but also if the person applying, their family, or anyone sponsoring them had used any public benefits in the past. And compare this new rule, which is supposed to go into effect on October 15, 2019. So anyone whose application was received before that date won't be subject to it, allows officials inside of the United States to consider this as well.
And when you say consider this, can you give us a little more information?
Yes, if a person has received government assistance for more than 12 months in a 3-year or 36-month period, each month they have received this will be counted as a point, which will be added together and tallied up, presumably weighted against the approval of their application. I like to point out that the 3 years is important because the 3 years they look at is 3 years before you apply for a benefit.
So if you received a public benefit 5 years before you apply, and you got it for 1 year, then they won't look at that?
It seems as if they would not, but since this is a new rule, we only telling you what is proposed right now. I hope you hear it because there's
I know, there's a
I don't know
motorcycle
why there's
driving around our office with really loud music. So
yes, so
just shows that we're live again. He's
yes,
right over there. Why
This is
can't
a
find
live-
stuff?
exactly. This is a live transmission, so I hope you hear us.
Okay, and if they receive more than one benefit, so say they got food stamps and housing, each one gets a point for each month that they got it, right?
Yes, that's right.
Okay, and you've told us what a public charge is. That's someone who gets government assistance. Does it apply to anyone applying for an immigration benefit?
Yes and no. It does apply to those applying for an immigration benefit, but it also excludes certain people. Those are individuals who are serving in active duty or in the ready reserve component of the United States Armed Forces and their spouses and children. Public benefits received by certain international adoptees and children acquiring U.S. citizenship. Medicaid for aliens under 21 and pregnant women, Medicaid for school-based services, including services provided under the Individual with Disability Education Act, and Medicaid benefits for emergency medical services. It's also important to note that this regulation does not apply to humanitarian-based immigration programs for refugees, asylees, special immigrant juveniles, certain trafficking victims, the T non-immigrants, victims of qualifying criminal activity, the U non-immigrants, or victims of domestic violence, also known as VAWA, self-petitioners.
Okay, so it sounds like while there's a lot of exclusions that you just went through,
Yeah.
for the most part, like a person who received a green card by marriage would still be scrutinized and might not be able to remove conditions from their green card or get their citizenship.
That's right.
And so if someone is a green card holder and is, say, we kind of went over this, but just to remind everybody, if they got Section 8 housing or food stamps, is it better if they don't apply to change their immigration status?
No, I wouldn't recommend that. There is one thing that can be allowed under the USCIS discretion that might allow someone who has received benefits to still be approved.
And what is that?
They can apply for something called a public charge bond.
And what does that mean?
Well, this is something new and it hasn't yet been put in place, but it is security for the U.S. government. If you did go on a public assistance, they could collect on this bond.
And so do you pay money to get it?
At this point, it shows that there is an application fee of $25, and beyond that, because the application and instructions are all still in the proposed stage, I don't want to try to give you more specific. That may change in the future. In fact, we did a video before about being a public charge, which we will put here in the comments a link to.
Okay. And I know that many critics have said that this is going to impact quite a few people.
That's true. Some estimates have been more than 800,000 immigrants currently in the United States that may be impacted. But as of today, 13 states have filed lawsuits against this rule. So I would caution people not to panic. And even if you have received public assistance, you may still be eligible to change your status. Of course, we recommend that everyone use an attorney because these rules changes are happening more frequently right now, and we do everything in our power to ensure if you're eligible that you obtain the benefit that you want. So thank you everyone who was watching, and please call our office to schedule a consultation. We are always here to help. Have a good weekend. Thank you.